You'll notice that Mr. Riley is not here this morning. In spite of the lack of any prior involvement, consideration, conclusion, and/or predetermination of the merits of the Coral Lakes II appeal in any form or fashion, he wanted to avoid any appearance to the contrary to the citizens of Sussex County and in deference to any possible concerns of the parties. He has thus decided to recuse himself from any involvement in the Coral Lakes II appeal that might have resulted from an interview in a public forum podcast earlier this past summer posted on social media. That interview referenced the existence of the Coral Lakes subdivision process. In addition, he wanted me to affirmatively state that he has not discussed the matter of the Coral Lakes II appeal in any form or fashion with any other members of the Sussex County Council. He has recused himself voluntarily to preserve the integrity of the process and to erase even the appearance of impropriety. In light of that recusal, I wish to state for the record that I've also spoken to each member of council, and each has indicated to me that he or she has had no prior discussion, consideration, bias, or opinions of any kind form regarding the outcome or any other aspect of in this matter from the date this matter was remanded to the Planning and Zoning Commission on June 23rd, 2023. Thank you, Your Honor.
All right. Any preliminary matters from council? Mr. Bartley?
No, Your Honor.
Ladies and gentlemen, as you are aware, this is the appeal of the decision of the Planning and Zoning Commission in Coral Lakes subdivision application number 2021-6. The appellees are Shell Brothers and the Planning and Zoning Commission, and the appellants are Mr. Bartley and the Hicks appellants, represented by Mr. Met. Is it Met or Meta?
Meta.
Meta. I thought that's what it was. And Mr. Bartley, who's appearing pro se. We previously met by teleconference and discussed the submissions and the preliminary issues that have been resolved. The appellees filed their submissions on September 21, and the appellants on October 5. That's in addition to their notices of appeal. The procedure will be that each side, proceeding with the Hicks appellants first, shall be entitled to 30 minutes, and then there will be questions by counsel. No additional evidence will be allowed, and this is a proceeding on the record before the Planning and Zoning Commission. And again, this appeal results from the decision of the Planning and Zoning Commission on June 23rd, 2022, following the remand from this council on May 24, 2022. I am the hearing officer appointed by County Council, Charles Tolliver, member of the Delaware Bar since 1975, I think. I can't remember. But my name is on the wall in the Supreme Court. I know I'm legitimate in that sense, and I also spent 24 years on the Superior Court of the state of Delaware, and I'm pleased to be once again in Sussex County. And I would also acknowledge that in response to my previously complaints about the seating, because I'm vertically challenged, they've amped up my chair and given me a pillow so you can see. And I sincerely appreciate that, because I never got that kind of consideration in Newcastle County, which says a lot from where I'm from. And with that, unless there is anything else from the members of council, we shall proceed with the Hicks appellants. Mr. Hunt? Oh, I'm sorry.
Thank you. Good morning, Your Honor. Good morning, council members. Good morning. Thank you for your time this morning. My name is Luke Mehta. I'm with the law firm Armstrong Teasdale, And I represent the parties or the appellants who have been referred to as the Hicks appellants. That is specifically Jill Hicks, William Hicks, Susan Petsy Rosenblum, Sergei Babushko, and Carrie Russo. I'm going to refer to them as the Hicks appellants, if that's okay. Your Honor, I realize that you've set aside 30 minutes. You want both of these down, or just
slide one over? Thank you.
30 minutes for argument. If I may, I would like to reserve some of my allotted 30 minutes for rebuttal.
So noted.
Our arguments on appeal were straightforward and simple. We argued that the record of the actual, candid, unscripted reasons given by the Planning and Zoning Commission members for their June 23rd vote demonstrated that the decision was not the result of an orderly and logical review of the evidence and applicable provisions of the subdivision ordinance, but rather the result of the commissioners voting the way their counsel told them or advised them to vote. We quoted the stated reasons given by the commissioners, 3 of which out of 5 are reflected on this slide, which on their face demonstrate that the reasons were not the result of the Planning and Zoning Commission's review or the commissioner's review of the evidence, certainly not an open session, and on its face which demonstrates that it was not the result of the commissioner's review of the applicable provisions of the subdivision ordinance. Their counsel and Mr. Whitehouse may have made determinations of code compliance, but the commissioners simply acquiesced. We argued that the only record evidence of what changed from the prior denial of the Shell application in March until its approval in June was the statements set forth on this slide and the obvious impact of counsel's advice and directions on the vote. Now, we also argued that the Planning and Zoning Commission failed to abide by this council's May 24 remand in 2 respects. The Planning and Zoning Commission did not consider the entire record, all evidence and facts of the application in open session. They simply did not do so. Certainly not in open session. The only thing that happened in open session was a hastily read verbal motion by counsel for the Planning Commission. The motion was immediately so moved, seconded, and voted on without any debate. There was no debate. There's no consideration in public session. We also argued that the Planning and Zoning Commission did not issue a written decision that you required in your remand. Did not issue a written decision containing the Commission's findings and conclusions, which thereby precluded effective review again by you. Now, nothing, if you actually, their briefs are well written and they're long, but if you actually look at the briefs of the Planning and Zoning Commission and Schell Brothers, both of whom are represented by fine individuals and fine lawyers, by the way, they don't really directly respond to any of the arguments that we make at all, not directly. They may engage in some evasive maneuvers, seeking to either muddy the record, which they cannot do, we submit under controlling Delaware law, and they try to convince you to avoid looking at what actually happened on June 23rd altogether by invoking arcane legal arguments such as standing and law of the case, which simply do not withstand scrutiny. So what was their direct response in their briefs to the actual reasons on the slide given by the commissioners for their June 23rd vote? They ran from the record. They ran from the record. They don't even quote the relevant highlighted section of Commissioner Stevenson. I was told, or our counsel says, we can't deny it. No mention of that at all. That should tell you something. When you run from something, it means you don't like it. And they did not even mention, we'll get into it here, the significance of the highlighted sections for Commissioners Wingate's and Mears' statements for their votes. Why did they run from the record? I submit because deep down they know this record cannot be upheld on appeal. Now, perhaps today, I saw the slides. I shared my slides with them. They shared their slides with us. So maybe today they will try to embrace what I've highlighted in yellow. We'll see. But if that's their move, if that's now they're going to pivot from their reply, from their answering briefs and embrace their stated reasons, then we're right back to where we argued in our notice of appeal. The Planning and Zoning Commission, not its counsel, fine man and fine lawyer, but the Planning and Zoning Commission, not its lawyer, is the body that's charged by statute and by Delaware law with reviewing and voting on applications, making findings, conclusions of code compliance, and stating their reasons, not somebody else's reasons, their reasons for the decision so that you can review it. Indeed, the code specifically requires that the Planning and Zoning Commission should act, the Planning and Zoning Commission should review, the Planning and Zoning Commission should decide. And we submit the Planning and Zoning Commission cannot simply abdicate its duties by simply delegating them to staff and council because it's convenient, or because that's the way we've always done it. A phrase I dislike. Remember the admonition, we cited this case in our opening brief, from the Delaware Supreme Court in the Tony Ashburn case. Delaware Supreme Court, Tony Ashburn case. That said, a planning commission most certainly has a measure of discretion. A planning commission most certainly has a measure of discretion, and they cannot simply rubber stamp an application such as this. We submit the Planning and Zoning Commission's discretion must be exercised, not abdicated. Exercised, not abdicated. And that here the Planning and Zoning Commission simply rubber stamped what their attorney told them to do without making any independent determinations of their own. This is not a check-the-box exercise. What was Shell's and Planning and Zoning Commission's direct response in their briefs to our argument that the Planning and Zoning Commission failed to comply with your remand instructions by failing to further consider the entire record, all evidence and facts of the application in open session, and to issue a written decision containing findings and conclusions consistent with law? I submit zero direct response to our argument, because there is none. There is nothing in the record. We'll show you. Here's what happened. There's nothing in the record that indicates that the Planning and Zoning Commission actually considered in open session the motion. Read verbally, 11 minutes, so moved, seconded, vote, bam. No discussion, no consideration. And with regard to the written decision that you asked or requested on remand, there's no written decision of the Planning and Zoning Commission at all. They point to a June 24th notice of decision. That wasn't signed by the Planning Commission, wasn't adopted by them, and it simply lists some conditions. It does not identify the reasons for the vote. So what do they do? What do they do in their briefs? Like an illusionist, they say, don't pay attention. Don't pay attention to what actually happened. Don't pay attention to the actual candid, unscripted reasons of the Planning and Zoning Commission members. Instead, look over here. Let's look at what we, the lawyers, did. A counsel's verbal motion, which took 11 minutes to read, spans 11 pages on the transcript. Let's take a look at a notice of decision. That's not a decision at all. Let's take a look at a pre-remand record, they say. Of course, that pre-remand record resulted in a denial of the application. So clearly, it cannot automatically result in an approval. Moreover, the case law is clear that their attempts to muddy the record, to confuse you, can only strengthen our argument that remand is necessary. You, on appeal, you should not be forced to speculate as to the reasons of the Planning and Zoning Commissioners for their June 23rd vote. We think it's pretty clear. And we'll get into it. We think it's pretty clear why they voted the way that they did. But if you're confused, and if they confuse you, then the only thing you can do under Delaware law is to remand. Because the Delaware case law we cite in our briefs make it clear that the Planning and Zoning Commission, in this instance, must state their reasons, and they have to be clear and not muddied. You are the governing body of Sussex County. You can remand the Planning Commission's June 23rd decision as you did with the prior decision. Indeed, we submit that you must. And you, not Planning and Zoning Commission's counsel, not Shell, is in charge of what happens next. So where are we? As we argued in our reply brief and our opening brief, the Planning and Zoning Commissioners are required and were required by Delaware case law to state their reasons for their votes on June 23rd. They were required to state their reasons for the votes on June 23rd. Delaware law requires it. The reason for that is to enable you to do a meaningful review on it. You in your remand order of May 24 required it, stating the reasons for their votes. And nothing in that remand order, by the way, says they only have to state the reasons for the vote. If it's a no vote, that's not what your remand order says. State your reasons, one way or the other. Counsel for Planning and Zoning Commission understood that. He specifically directed on the 23rd, he specifically directed the commissioners to state your reasons for your vote. Yes or no. Yes or no. Not just no. Yes or no. And they did so. And that's what they did. They stated their reasons on the record. So let's take a look at what they actually said. We'll get into it here. Not the lawyer's post hoc rationalizations, not the lawyer's verbal motion that was not debated in open session, and not the notice of decision that the Planning and Zoning Commission did not sign or adopt. Let's look at the actual reasons for the June 23rd vote. At least 3 votes out of 5 were directly based on instructions from the Planning and Zoning Commission's counsel rather than an independent judgment of the commissioners themselves. Let's look at Commissioner Stevenson. Commissioner Stevenson abstained because, quote, because I was told what our counsel said was that we can't deny it. That statement, I submit, could hardly be clearer. And again, in their briefs, what's their response? Crickets. Silence. Nothing. They hate that statement. Let's look at Commissioner Mears, who had previously voted against the application in March and now stated, quote unquote, unfortunately, I'm a yes because, quote, pay very careful attention, as counsel explained it, as counsel explained, it complies with the subdivision code and the zoning code. And therefore, I vote yes based on the reasons in the motion. At most, Commissioner Mears' statement reflects counsel's determination of code compliance, not Commissioner Mears. As counsel explained it, it complies. That's the statement. How about Commissioner Wingate? Mr. Chair, I am a yes because of the extensive explanation by counsel. By the way, counsel doesn't vote. He's not a member of the Planning and Zoning Commission. He doesn't get a vote. Sometimes commissioners will adopt the reasons given by another voting member. Right? Sometimes that happens. Counsel for the Planning and Zoning Commission doesn't vote. He just provides legal advice. You can't adopt the reasons of a non-voting member. Moreover, Commissioner Wingate says, I voted yes because of the extensive application by counsel and the condition imposed. The condition imposed. That's not a finding or determination of code compliance. The condition imposed is not a finding of code compliance. Once you've made a decision of code compliance, you can attach conditions that are consistent with the spirit and intent of the code. But a condition imposed is not a finding of code compliance. These 3 people, these 3 commissioners, 3 out of 5, did not make their own independent determination of code compliance. It is clear and unambiguous from this record. Now, we submit that record cannot stand on appeal before you. The June 23rd vote was not the result of an orderly and logical review of the evidence and the applicable provisions of the subdivision ordinance by the commissioners. The commissioners voted the way they did because their attorney told them they can't deny the application, or because their lawyer made the key finding of code compliance. And they just did a 180 from their prior vote in March and turned it down. Now, it's okay for a lawyer to explain what the law is. Judge Tolliver, when he was giving jury instructions to a jury, would tell a jury what the law is. But lawyers and judges don't tell the people who are voting how to apply the law. That's their job. Not the judges, not their lawyers. That's their job. And they didn't exercise it. And this matters. This matters, folks. This is not some sort of arcane argument. This is not how government is supposed to work. It's contrary to the language in your code, contrary to the admonition by the Delaware Supreme Court in the Tony Ashburn case, and it's contrary to any notion of good government. In fact, ask yourselves, why even have a zoning commission? Why even have a zoning commission if they're just going to rubber stamp what staff and their counsel tell them to do? That's idiotic. It's silly. It cannot be. We think the record is clear in this. You must remand, and you should ask yourself, I respectfully submit, why is the Planning and Zoning Commission, why is Shell fighting so hard to prevent you from remanding this matter back so we can get a clearer understanding so that the entire community, a lot of people here today, as to really what exactly happened? Why did they do a 180? What really caused them to change their decision from a no to a yes? Is there something else going on here? I should hope that you would want to know the answer to that question. And there's only one way to find out. Remand. Remand. You are the senior representatives of Sussex County government. I, again, respectfully submit. You should ask yourself, how do you want the Planning and Zoning Commission decisions to be made? Are you comfortable with this record? From a 4-1 against to a 3-1 in favor simply because their attorney said you can't deny it, and otherwise made determinations of code compliance for them. And I submit respectfully that a court would not be comfortable with this record. So remand. So let's dig in a little bit deeper into the arguments that the Planning and Zoning Commission and Shell make in their briefs, which do not stand up to any scrutiny, I submit. First, they say they rely on the June 23rd verbal motion. Now, that motion is still not written. It took 11 minutes and 11 pages to read into the record by the Planning and Zoning Commission's counsel for whoever wanted to make it, he said. For whoever, I'm going to read an 11-minute motion for whoever wants to make it. Immediately after it was read, so moved, seconded, vote. No debate. And most importantly for you, no discussion as to the reasons why they were voting the way they were going to vote, or consideration of the evidence, or consideration of the record, or consideration of applicable law other than that. The motion could not possibly have been considered in open session. Look what happened. This motion could not possibly have, it was just read for 11 minutes, very quickly. It could not possibly have been considered in open session. It's impossible. Now, perhaps it was discussed in executive session or private session. But then you got a FOIA problem. And that's also directly contrary to your own remand that it be considered and reviewed in open session, as FOIA requires. I've seen the argument, and maybe they'll make it again today, that, well, you know, lawyers read motions into the record all the time. That may be, but that's not what we're talking about here. We're talking about, did the commissioners independently articulate their reasons for their votes? You have to look at what actually happened here. Next, the pre-remand record. They, in order to save the June 23rd vote, they rely on the pre-remand record. You remanded on May 24. Well, let's take a look at the pre-remand record. But of course, that record resulted in the Planning and Zoning Commission denying the application in March. And of course, this council, more importantly, specifically ordered the Planning and Zoning Commission or remand to conduct a further consideration of the entire record, all evidence and facts of this application, again, in open session. And the cases that we cited, I submit, make it clear that you cannot uphold this decision based on the attorney's post hoc rationalizations, based on a record that they interpret in their briefs, and on a motion they read that was not debated, and on a notice of a decision that's really not a decision at all. But most importantly, you should not, if there's one thing I want you to remember today, you do not have to speculate as to really what was going on. If there's any doubt in your mind as to really what was going on, why did they do a 180? Why did they suddenly turn it down? If you have any doubt whatsoever, you must remand. That's what the Delaware case law that we cite submits. And as to the June 24 notice of decision, that doesn't say the June 23rd vote. Again, it's not a decision. Normally when a public body issues a decision like you ask them to issue, like they sign it and adopt it, the June 24 notice of decision does not even purport to be an actual decision. It's a post hoc notice of decision that doesn't state the reasons for the decision. It simply lists the conditions of approval. It's not signed by the commissioners as you would expect. It does not contain any findings of code compliance. And we submit that the June 23rd decision did not comply with your May 24 remand instruction that the Planning and Zoning Commission conduct a further review of the entire record, all evidence and facts of this application in open session. Again, it simply did not happen. And I think that Planning and Zoning Commission shall realize that it did not happen. If you look at their briefs, they say things, well, you got to look at the vote in this whole context, and maybe they sort of implicitly meant, it's in their briefs. Once you go there, you're conceding it didn't happen. Once you go there, you're conceding it didn't happen. Now, it is in this context that we raise an appeal whether the commission, rather than its lawyer, actually made a really important determination regarding code compliance, and that is whether Shell's application complied with applicable law that was enacted in 2021, the so-called superior design requirements. Now, the application was filed on November 25, 2020, and it was not filed by Shell Brothers, but rather by Double DBLP. And Shell now admits in its papers that it had not been recertified. Its application is a 2021 number, not a 2020 number. And the record is devoid of any analysis by the Planning and Zoning Commission, at least by a majority, or anybody other than their lawyer, that this impacts, or whether this fact impacts which version of the code should apply to the application, 2020 or 2021. Our argument on appeal is to be clear before they jump up and start screaming. The record of this decision does not indicate that the commissioners made that key finding of code compliance, consistent with our argument. I'm not taking a position one way or the other on the merits of that argument. I'm saying the record does not support that the commission made a finding of that key determination. And finally, the June 23rd decision did not comply with the remand requirement that the Planning and Zoning Commission issue a written decision containing findings and conclusions that are consistent with law. Again, my final minute or two before I reserve 5 minutes, let me close with this. Good government and Delaware law requires more, respectfully, than what the Planning and Zoning Commission did on June 23rd. Regardless of how busy they are, regardless of how many of these things they have coming through their pipes, they have to do their job. The Planning and Zoning Commission must make independent findings of fact and conclusions of law regarding code compliance. Their decisions, not somebody else's. Now, subdivision approval is not a check-the-box exercise. Remember Tony Ashburn. It's an important decision, especially in Sussex County, given the amount of development in Sussex County. Now, some people say there's nothing people can do, there's nothing government can do to regulate development. That's not true. At a very minimum, there's one thing that you can do. You can insist that the Planning and Zoning Commission actually comply with your remand order. And you can insist that the Planning and Zoning Commission comply with Delaware law and the code and state their reasons for their vote and exercise their discretion rather than abdicate. Thank you.
How do you wish to respond? Do you wish to reserve, Mr. Robertson?
understanding that we were going to let both appellants
Sounds-
go first, and then, just for everybody's benefit, I was going to speak next, addressing both appellants, and then Shell, I think, was going to speak. However, they're going
That was my recollection as well, but I wasn't sure you
Yeah,
would
no,
want to stick to that.
That's how we were approaching.
Okay? Thank you, sir.
Thank you.
Mr. Bartley?
And sorry, Your Honor, I would stand up on the crane.
Good morning, and I'm very sorry for being late this morning. Judge Tolliver, President Vincent, Councilman and Councilwoman, I am Terry Bartley, and as you know, I have appealed the Planning and Zoning Commission's decision of approval of Shell Brothers' application for Coral Lakes. Given the council is well acquainted with the facts of the application and the procedural requirements of this appeal, only the arguments of each ground of appeal will be provided. The Commission failed to provide adequate notice. Sussex County Code 99, Section 99A, and the Delaware Code 96812 regulated Coral Lakes public hearings notice as follows. Any public hearing required by this chapter shall be held within the county, and notice of time and place thereof shall be published in 2 newspapers of general circulation in the county. Notice shall be published in at least 15 days before the date of the hearing. In addition, notice of the hearing shall be posted on the property itself. The notice shall state the place at which the text and maps relating to proposed change may be examined. The record of the hearing for Coral Lakes has affidavits for the placement of 2 advertisements. Neither advertisement states the place at which the text and maps relating to the proposed change may be examined. Delaware Supreme Court Chief Justice Herman, in a 1982 land case, stated, "The objective of the required notice is to announce the purpose, dates, and times of the hearings, describe the area to be subdivided, and advise the public of its right to inspect the relevant documents in advance and its right to be heard at the hearings. For the public to avail themselves of their rights, specifically to inspect the relevant documents in advance, it is imperative for them to know where the documents are located." Chief Justice Harriman, in the same case, continued by declaring that the use of the word "shall" in the notice statute indicates the legislative intent requiring mandatory compliance. The enabling statute must be strictly followed. Council must apply the strictly adhered to standard and find that the Commission, by failing to strictly adhere to Section 99A of the Sussex County Code and 6812 of the Delaware Code, resulted in the improper interpretation and application of the county code. The Commission's advertisement's wording, additional information pertaining to the applications may be reviewed online at sussexcountyde.gov prior to the meeting, does not meet the requirement of 9 D.C. Section 6812. The website, sussexcountyde.gov, is not a place. The website does not address the part of the public who do not have Internet access. The website is a large website. To attempt to comply, the Commission would at least have to give an ULR address. Just as buildings have a street address, web pages also have unique addresses to help people locate them. The required property sign of the hearing states, text and maps of this application may be examined at the County Administrative Office building. The required newspaper advertisements for the hearing states, additional information pertaining to the application may be reviewed online at sussexcountyde.gov prior to the meeting. Logically, the Commission cannot claim there are 2 different places at which the text and maps relating to the proposed subdivision may be examined. One of the notices must be in error. Given that Planning and Zoning Department is an actual place, then the advertisements reviewed online must be in error. Appellant Hicks' testimony raised the issue that the notice did not comply with 6812. The following passage of Appellant Hicks' testimony from the transcripts of the hearing states, "And even the differences in the site plan on the file at P&Z could be requested at December 18th, 9 days ago, and the plan provided to the public in the online packet 3 days later on January 21st, of which there were changes made. Therefore, we request the current plus review be performed." Clearly, 6812 requires one place where the public can review all the documents related to a subdivision. The Commission cannot have multiple locations with different documents in each location where the text and maps relating to the proposed subdivision may be examined. Ms. Hicks notifies the Commission that the documents located in the Planning and Zoning Office are different than the documents contained on the online packet. As a matter of fact, the majority of the online packet, hundreds of pages, is still not on file at the Planning and Zoning Office. Given that the Council's decision must be based on the record, I hope Council takes the time to go through the official record from Planning and Zoning and you can determine quite easily what pages of the online packet are not included. The right to inspect the relevant documents in advance of the hearings is governed by 6812 by setting the time frame of the meaning of in advance as at least 15 days before the date of the hearing. Clearly, the Delaware legislature would not require a notice date to place at which the text and maps relating to the proposed change may be examined, and not require the documents be there. That would have the public inspecting the documents which do not accurately reflect the subdivision application. The Commission is not free to arbitrarily set a date shorter than 15 days. Ms. Hicks notifies the Commission that the online packet was only available to the public for 7 days before the hearing. Given the applicant had over a year to prepare a record of support, fundamental fairness would require they make available to the public the online packet, which was a 276-page report within the statutory required 15 days. In summary, there were 3 locations where the text and maps were located for Coral Lakes. First, the official record located in Planning and Zoning Office. As stated above, it does not contain hundreds of pages of the online packet. Clearly, it is not in compliance with Section 99A. Secondly, online, where the Planning and Zoning agenda was located. From Ms. Hicks' testimony, we know this was only available 7 days before the hearing. Clearly not in compliance with Section 99A. Thirdly, the online land use docket. This is the only location online that had Coral Lakes listed on when the Cape Gazette ad was published and when the statutory 15-day period passed. Unfortunately, there was no text and maps listed. I visited the site several times for the hearing to review the information. There was never any information listed, clearly not in compliance with Section 99A. The Commission's failure to provide proper notice was a fundamental error. The fundamental error doctrine is an exception to the rule that issues cannot be raised for the first time on appeal. Given land use has constitutional protections, notice requirements would be a matter of due process. In fact, courts have said the fundamental error must be equivalent to the denial of due process. All wetlands simply means all wetlands. The applicant, when deciding to develop these parcels, understood that wetlands would be the defining feature of this application. The Coral Lakes is a cluster subdivision application which are governed by Code Section 115.25. Logically, the applicant would look to the Code 115.25 to find the regulations which govern wetlands. Wetlands for cluster subdivisions are regulated by Code 115.25e. Design requirements for cluster development states that all lots should be configured to be contained completely outside of all wetlands. The applicant should then develop a record of substantial evidence to support the Commission's findings of fact. The applicant did not mention, consider, or develop evidence for the application complying with Code 115.25e in its record of support. There is no evidence that the Commission mentioned, considered, or developed evidence for finding the application complied with Code 115.25e in the record of support. The Commission gave no evidence to support the notion that the meaning of Code 115.25e, all wetlands, only included jurisdictional wetlands. The applicant's counsel made the false argument that all wetlands only applies to definition of wetlands contained in 115.93. Buffer zones are wetlands in tidal and perennial non-tidal waters. However, 115.93 states, definitions as used in this section, the following terms shall have the meanings indicated. The applicant's process is identifying and excluding non-jurisdictional wetlands should only be utilized when applying buffer regulations and should not be applied to cluster development regulations. The County Council regulates land use in Sussex County, not the federal government. Any federal regulation should be enforced in addition to the zoning code regulations and not in place of. The Army Corps of Engineers approved jurisdictional delimitation lists 3 wetlands. Wetland C, 12.75 acres, Wetland D, 5.31 acres, and Wetland E, 0.3 acres. The applicant's record of support shows upwards of 18.36 acres of non-jurisdictional wetlands. On page 6 of the Plus Review, Beth Remine from DENREC stated, the newest project application proposed to disturb fill upwards of 25 acres of non-tidal wetlands. These non-tidal wetlands provide significant flood attenuation, water quality, benefits, and habitat for plants and animal species. Filling these wetlands areas, then building homes and infrastructure upon them will directly result in an adverse drainage and flooding impacts for future residents. DENREC is a state agency charged through the PLUS process to give recommendations concerning the environment and wetlands specifically. DENREC gives the Commission evidence that the required design element 115.25e design requirement for cluster developments states that all lots shall be configured to be contained completely outside of all wetlands, will not be met. The Commission is not free to ignore this testimony. They must on the record give the reason why they did not agree with the testimony. The record has no evidence the Commission considered the code after Mr. Stevens brought it to their attention. The Commission did not address DENREC's submission that filling these wetlands areas, then building homes and infrastructure upon them will directly result in adverse drainage and flooding impacts for future residents. This resulted in the improper interpretation and application of the Sussex County Code 11525E. The record fails to affirm the application follows the code. The Commission failed to follow Code Section 99.8b. The Code 98b requires that the preliminary plat shall be checked by the staff to determine its conformity with the county's official zoning map. Other pertinent features of the comprehensive plan of the county, applicable zoning and other regulations, and the design principles and standards and requirements for the plat submission as set forth in this chapter. The planning and zoning staff prepared a review to comply with the preliminary plat shall be checked by the staff, requirement of Code 99.8. In the staff review letter of the review, the Planning and Zoning Planner 3 notified the applicant and the Commission that the preliminary site plan did not contain a grading plan and an easement for the site plan. The issue of Code 99.8 not being satisfied was raised by the Planning and Zoning Planner 3 as part of a statutory process. The applicant, in the response to the staff review, stated that for the site plan will be completed in the for the site plan for the easements and the grading will be completed in the final site plan. The grading plan and the easements are required elements of the preliminary site plan. There is only one logical conclusion. The applicant's record of support through the response does not comply with the subdivision code. There is no evidence in the record that the planner or staff received response. There is no evidence in the record that the planner or staff made any determinations concerning the applicant's assertions that they cured the identified deficiencies. The Commission's counsel addressed the importance of this step at the first appeal of Coeur Lakes. Mr. Robertson pointed out that you must then have staff review. The argument is that if the plat is compliant, it must be approved. Mr. Robertson explained that you are not able to just take someone's word that it is compliant. There has to be a staff review and occurs to ensure that the plat submitted is compliant with the county's subdivision code. Based on the record, one must conclude that the Commission, the director, and the staff just accepted the applicant's word that the plat submitted was compliant. By an act of omission, the staff did not ensure the plan complied with zoning and subdivision code. The Commission, in their motion to approve the plan, included Condition S. The final site plan shall include a grading plan for the site. The Commission concurred with the applicant that the preliminary plat does not have to be required grading plan. Conditions placed on subdivision approvals are intended as reasonable conditions which the Planning Commission may impose in order to minimize an adverse impact on nearby landowners and residents. Conditions are not intended as curative measures to address any plat deficiencies of specific criteria found in an ordinance. The mere fact the Commission required the applicant to include a grading plan in the final site plan shows the plan is not in compliance with 99.8b. The Commission's failure to hold a fair and orderly public hearing. For an application that has had a lot of controversy, there is one thing everyone agrees on. When the record was closed, all four parties, the Commission, the Council, the applicant, and current appellant, agreed that the record was closed on January 27, 2022. In Council's resolution remanding the application back to the Commission, the Council instructed the Commission to further consider the entire record, all evidence and facts of this application in open session, to consult with their legal counsel, to take a public vote thereon, and instructions to clearly state the record reasons in support of the Commission's vote. The Commission, at its June 23, 2020 meeting, included Coeur Lakes as an agenda item to comply with the Council's instructions. First up at the meeting was the Commission's legal counsel's consultation with the Commission concerning the application. This consultation comprised 6 pages of transcribed testimony to discuss the well-settled law on subdivisions in Delaware. This discussion reviewed 8 citations of court cases, the Delaware Code, the Zoning Code, the Subdivision Code, the Commission's Rules of Procedure. The Commission's Council discourse ended with, so again, in summary, under a well-established Delaware law, if a subdivision satisfies the requirements of the Zoning Code, the Subdivision Code, then it must be approved. Next up was to take the public vote thereon based on the entire record. However, there was a problem. The plan must satisfy the requirements of the Zoning Code and the Subdivision Code. so it can fulfill the if-then condition of the council's summary above. As previously established, there was an evidentiary defect in that the record is void of any oral or written presentation that the director or the staff determined the plan conformed with the zoning and subdivision code. At the conclusion of council's remark, he stated the following. So based upon the law that I have described, I now ask Mr. Whitehouse to confirm for the record, emphasis added, whether subdivision 212006 for Coral Lakes complies with the subdivision and zoning code. Mr. Whitehouse replied, and it does, Mr. Chairman. The bulk area, open space density, and buffer requirements within Chapter 115 are complied with, and the design requirements in Chapter 99 are also met. Council's question and answer session with the director was clearly a curative step to address the evidential defect in the record. But at what cost? Now there is a procedural defect in the evidence as added to the record. After it was clearly closed, in a twist of irony, the director's declaration that the application complied with the code outside the record must be construed as an admission that he never confirmed the application confirmed with the code on the record. Council instructed commission to consult with their counsel. The council consults that if the application complies with the zoning and subdivision code, they must approve it. Then the council has director outside the record confirm the plan does not comply with the zoning code. It does comply with the zoning and subdivision code. Given these set of circumstances, one must conclude that the procedural error was a fatal to the application, and that the council and director's actions were prejudicial to the application receiving a fair and orderly and logical review. The commission, by allowing and considering evidence presented outside the public hearings record, allowed for a decision that was not the result of an orderly and logical review of the evidence. Appellate Bartley is given standing by Title 9, Delaware Chapter, Section 6811. Title 9 of the Delaware Code, Section 6811, gives the residents of Sussex County an explicitly created right of action to challenge a site plan approval by the Sussex County Planning and Zoning to the Sussex County Council. Delaware Code, Section 6811 states, any approval or disapproval of subdivision application may appeal to the county government within 30 days of the official action of the county government. The commission and applicant failed to recognize this fact when citing cases to challenge Appellant Bartley's standing. The primary case cited by the appellant's counsel was Citizen for Smyrna Clayton First. Smyrna is a municipality and is not governed by Delaware Code 6811. Applicant's counsel failed to take note of a key element of the master's report for Citizens for Smyrna Clayton First, which they supplied with their written submission. Counsel has that readily available for them to review. On page 5, the master found that Smyrna residents have no explicitly created right of action to challenge a site plan approved by the town council. Further, on page 5, the master report continues. The standing test applicable to cases where, as in this challenge to the actions of town council, the plaintiff seeks review of a decision without any statutory right of appeal. The plaintiff must demonstrate an interest distinguishable from the general public's interest. Given that Delaware Code 6811 gives the residents of Sussex County an explicitly created right of action to challenge a site plan approval by Sussex County Planning and Zoning to the Sussex County Council, Sussex County residents have a statutory right of appeal. Therefore, Sussex County residents do not have to demonstrate an interest distinguishable from the general public interest in subdivision appeals before council. I will cite Citizens for Smyrna Clayton First. Again, applicant's counsel failed to take note of a key element of the master's report for Citizens of Smyrna Clayton First, which they supplied with their written submissions. Once again, counsel has readily available to them to review the applicant's case-cited submission. On page 7, the master found the plaintiffs alleged the town, in failing to follow certain procedures set out by ordinance, deprived them of the right of due process, a claim which confers standing to seek redress in this court. The master cites Couch v. Demelver Power and Light and Company. Thus, with respect to those claims, the plaintiffs are entitled to determination on the merits. I will cite Citizens for Smyrna Clayton. First, appellant alleges the commission deprived him of his due process of notice by not following the notice of procedures of Sussex County Code 99A and Delaware Code 96812. Determinations. Based on these findings and declarations and review of the record, council's only logical determination of the commission's decisions was not a result of an orderly and logical review of the evidence and involved improper interpretation and application of zoning and subdivision code. Given these errors, council's only just and reasonable course of action is to reverse the commission's decision approved for Coral Lakes. Thank you for your time.
Do you reserve time for
Yeah, can I
rebuttal?
reserve my time, please?
We're going to take a very short 5-minute recess, please. If that's okay with you.
It's up to you. We need a motion, Mr. Moore.
Yes.
Entertain a motion to do a 5-minute recess.
So moved.
Motion, Mr. Hudson. Second, Mrs. Green. Question on a motion. Take the vote. Mr. Schaefer. Mrs. Green.
Yes.
Mr. Hudson.
Yes.
I will yes. We're now in a 5-minute recess. Entertain a motion to go out of recess to regular session. Motion, Mr. Hudson. Second,
Second.
Mrs. Green. Questions on the motion. Take the vote. Mr. Schaefer.
Yes.
Mrs. Green.
Yes.
Mr. Hudson.
Yes.
I will yes. We're now back in regular session. Judge Tolliver.
Let me apologize. I'll move the microphone closer. In addition to being vertically challenged, I'm soft-spoken. It's 2 strikes. Mr. Robertson?
Thank you, Your Honor. Members of council, Vince Robertson of Parkowski, Girk and Swayze on behalf of the Planning and Zoning Commission. I'm here before you this morning, it's still this morning, on a bit of an unusual situation. Usually lawyers are defending clients who don't listen to what the law is. Here I'm defending a client that's being challenged because it did listen to what the law is. In this case, I want to start with the fact that Coral Lakes was a coastal area subdivision. It was not a cluster subdivision. The superior design standards that apply to coastal or to cluster subdivisions do not apply. As you all may remember, that was changed. We superimposed those on all subdivisions that use the cluster design. So subdivisions like this are by right. Some people may not like that, but that's the law as outlined in the briefing. If the code is follows on a subdivision, it must be approved. That's what East Lake and Ashburn and other cases, even cited by Mr. Mehta, state. The commission is allowed to impose conditions, which was done here. There are actually 21 of them that were imposed in this case. This law is not disputed by anyone. The Hicks appellants don't like that I explain the law, but they don't dispute my explanation of it. They don't even cite to my explanation of it. So with that, I want to take a moment to talk about the standard of review on one of these appeals. It's governed by Section 99-39 of the Subdivision Code, and what you need to look at is whether the Commission correctly applied and interpreted the code and whether there was an orderly and logical review. We believe that both of those occurred, and therefore the decision of the Planning and Zoning Commission should be affirmed. I'm going to address the Hicks appellants first. They argue 3 reasons for reversal. 1, that the commission did not follow county councils. There's legal counsel and county counsel. It gets confusing when we start talking about those 2 terms. But the Planning and Zoning Commission did not follow county council's instructions. They say that the commission did not conduct an orderly and logical review, and they say that the record fails to demonstrate that the commission's decision was the proper application of the law. With regard to counsel's instructions on remand, counsel specifically directed the commission to consult with its attorney. I want to say that again. The counsel, you all directed the commission to consult with me as the commission's attorney. There was all sorts of arguments stated that that shouldn't have happened or why did that happen. That's what you told the commission to do on remand. Again, the Hicks appellants never dispute the legal advice provided by me or the law in question regarding subdivisions. In fact, they do cite the same law. And this was not the first time that this legal advice was given. As you may recall, prior to the first vote on Coral Lakes, Commissioner Stevenson asked me to give an explanation on how subdivisions are treated in Delaware. Neither appellant took issue with the specific advice that was given then or now. Instead of disputing the law, the Hicks appellants dispute the ability of me to advise my client, the commission, about what the law is. That is what I was appointed. That is what I was appointed to do, and that's what I was directed to do by you. With regard to the motion itself, I think what's lost in all this on that consideration back in June, that was not the first time that the Commission had seen this motion. Recall that a nearly identical motion was made back in March, and the Commission considered that, and there were 4 votes against that motion. There were no reasons given for that motion. And we had a motion to approve and then 4 votes to deny, and there wasn't any reason given why those 4 votes to deny should have been made. But the fact of the matter is they had seen the same motion back in March. They had 3 months to consider what that motion said. It was considered again back in June. In that context, I think you also ought to take notice of the fact that all of the Hicks appellant's arguments ignore the motion itself. They never talk about the findings that were in that motion or the conditions that were in that motion. They do state that it was a long one. It was 11 minutes. That's true because it was an extensive motion with a lot of detail in it based upon the record. Instead, they seem to suggest that each member of the commission has to restate or paraphrase the entire motion whenever voting on it. That's not required. Was it read by me? Yes. Is that permitted? Yes, and I'll get into that shortly. But that motion was made by Mr. Mears, and it was seconded by Mrs. Wingate in her during the meeting, and then it was voted on. It was an independent vote. Nobody had to make the motion. Nobody had to second it, and everyone could vote how they wanted. In fact, we ended up with a 3-1-1 vote. It wasn't unanimous. If this was a done deal, you'd think it would have been a 5-0 vote, and it wasn't. It was the commission's motion. And we see from what Mr. Mehta put on the screens earlier that the commissioners who voted on it, they referenced the reasons given in the motion as their reasons why they voted for it. And I want to just refer back to that, too. There was questions about, who drafted the motion, et cetera. Recall that it was the same motion made back in March for the most part. Back in March, that was stated by Ms. Stevenson back on the March 10th, 2022 meeting that she admitted that we worked very hard on this. It wasn't me. It was the commission worked very hard on it. And then going forward into June, it was their motion. You all cannot ignore or look past the motion itself and its specific findings as the appellants would suggest. Was there an orderly and logical review? You have to look at this holistically. This wasn't a rehearing, it was a remand. We didn't have a whole other hearing again at Planning and Zoning. We weren't instructed to do that. It was a remand. So it was based on the record that was made back earlier this year. So when you look back at that hearing, what did the commission discuss? They talked about wetlands. There was discussions about impacts on adjacent development. There was discussions about interconnectivity. There was discussions about stormwater design, the impact of the development on Sarah Run and Love Creek. Questions from the commissions to DelDOT. More discussions about drainage. Discussions about adjacent developments. There was discussions about archaeological studies. There were discussions about adjacent airplane landing strips and the effects of those. Then, the motion made it the first time and again on remand stated that it was based upon the record. Again, there was an orderly logical review because it was based on that record that occurred at that hearing back in early 2022. There was no speculation into why this was approved. There were specific findings related to density, a denial of the bonus density lots for the protection of trees and federal wetlands, addressing DelDOT requirements. The motion addressed the Henlopen TID. The motion addressed the 17 items of Section 99-9C, and there were conditions that related back to that. It addressed central water and sewer. It addressed the coastal area provisions of the comprehensive plan. It required perimeter and wetland buffers and the preservation of trees and other vegetation within that. It addressed that there had to be at least 30% of the site being contiguous open space. It addressed the fact that there was maintenance of streets, roads, buffers, stormwater management facilities, and common areas by an HOA. It talked about sidewalks and street lighting. It talked about amenities. It talked about internal street design and road naming, and it actually required an entire street to be removed and relocated within that subdivision. It talked about the agricultural use protection notice. It talked about the existence of a nearby airfield. It talked about a notice requiring nearby neighbors to be aware that there were hunting activities in the area. And it even talked about what should happen if there were grave sites located in the subdivision. Although the Hicks appellants would ask you to do that, to ignore that, you all can't ignore those findings and those conditions. And I'll just point out, you don't have to take my word for it, there were cites to the record for each of those at pages 13 to 15 of our written submission. The Hicks appellants next acknowledged the rule of Eastlake Partners and Tony Ashburn and state about, there can't be a rubber stamp when they say the commission has the further right to scrutinize the layout of the project as depicted on the site plan and attach conditions to it. Again, that's exactly what happened. They're telling us you got to do that? We did it. In addition to the 16 findings, there were 21 conditions of approval doing exactly what Eastlake and Ashburn allow. Finally, Council has already determined that an orderly and logical review occurred in its first decision on this subdivision, and it cannot reopen that prior finding. With regard to me reading the motion, there's no issue with that. That is supported by Mason's Manual of Legislative Procedure, which allows others to read a motion. It is consistent with legislative motion practice in the state and here in Sussex County. There are examples provided of that to minutes, and that included Terrapin Island, which was approved by this council on appeal. That goes back, at least with my tenure, to Leighton Johnson and Ronald Lynch when they were on the commission. Those two gentlemen asked me to read motions for them all the time. That practice has continued right through this day for a variety of reasons. It is a non-issue and irrelevant to the substance of this appeal. And it is noteworthy that the Hicks appellants never disputed the legal advice that was incorporated into the motion. In summary, the motion that was made, seconded, and approved was by its own terms, based upon the record, 16 separate findings and 21 conditions. And the 3 votes in favor of that motion adopted it as their own. Mr. Meadows spent some time reviewing court cases that talk about how a court needs to know exactly and in detail why the subdivision was approved. They cite T.D. Rehoboth versus Sussex County in their written decision, and Tate v. Miles, where the court said that the county council in both of those cases had to make a record so that the court could adequately review the decision. Those are distinguishable from what we have here. As you all know, at council, unlike P&Z, a short title is read, somebody says, "so moved," there's nothing more, then each council person has to give his or her reasons why they're voting on that motion. When the motion's substance is only "so moved," the response, "I vote yes," doesn't cut it. You need more reasoning so that a court on appeal can decide why you voted yes. Here, there was a very specific motion made with 16 separate findings and 21 detailed conditions. Quoting Tate v. Miles, the Commission created a record for its decision through its motion. It's clear to any reviewing court why it was approved. We only need to look at the court chancery case of Gibson v. Sussex County, which was a conditional use for this being okay in the court's eyes. In Gibson, the court quoted the Commission's specific reasons given in its motion, like what was done here, and found that this was, quote, articulated reasoning evincing a thorough and rational review. It looked at the motion, not the individual votes. It also commended the Commission's caveats imposed in the form of the conditions, many of which mirrored the purposes of the pending conditions in this case. Ultimately, the court's remedy in Gibson was to affirm the Commission's reasoning and conditions. Here, Tate versus Miles, T.D. Rehoboth, Gibson, and even Terrapin Island confirmed that the Commission's motion does provide adequate justification for the Commission's decision, and it gives everyone reasons why Coral Lakes was approved. With regard to the question of a written decision, it was issued by the Commission staff on June 24, the next day following the vote. That's not in dispute. This was in accordance with the requirements of Title IX that talk about the type of decision that should be issued. And in that case, it talks about a decision being issued in the case of a disapproval. Here, we had an approval, but we still issued a written decision. We also need to look at Planning and Zoning Rule 15.4, which provides further guidance. It says, following a decision by the Commission on an application, a copy of the written decision shall be sent to the applicant. That also occurred. There was a written decision issued and sent. The Hicks appellants attempt to attach different requirements to that, but that's not anywhere in our code or Title IX or anywhere else. There's no requirement that it has to be signed by individual members of the Commission. That may be a practice some places. I know that it is in some local jurisdictions. That's not a requirement here in Sussex County. It's not in our code, not in our rules. There's a question in their briefing about who it was addressed to. It was sent to the applicant as required by Title IX and our rules. So we submit that there was a written decision in compliance with the Commission's rules. So in summary, with regard to the Hicks appeal, Planning and Zoning did follow the Council's instructions. Planning and Zoning, their decision was an orderly and logical review. And it is not disputed that the record demonstrates that the decision was the proper application of the law. With that, I'd like to turn to Mr. Bartley's arguments. I do want to first address the question of standing. I think it's important for everybody here to understand Mr. Bartley did not even appear at the hearing. He did not submit anything into the record during the hearing. He stood by and did nothing when he could have participated. There's a question of how you can claim to be aggrieved when you didn't step up at the hearing in the first place. That would have been the time period to raise your concerns about a subdivision, make them known to the Planning and Zoning Commission, and then fall back on them in appeal. Here, he didn't do that. He does not live in close proximity to the subdivision. He does not allege in any way, shape, or form how he's an aggrieved party. Again, what's his injury? He didn't even show up to the hearing in the first place. That's a minimum threshold requirement of 99-39, and Mr. Bartley has not satisfied. So with that, I would submit, as we did in our written submissions, that his appeal should not be considered by counsel. Reserving that, I'm going to go forward and address his items that he raised in his appeal and his written submission. The first one is the notice requirement. I'm going to stand by the statement that we made in our written submission that this was an argument that was not raised below. Mr. Bartley wasn't there, and nobody else raised it during the public hearing, so it cannot be raised now on appeal. And that's in accordance with Judge Tolliver's September 16, 2022 ruling, where he said even if timely raised, an argument or evidence not part of the record below cannot be considered on appeal. Mr. Bartley tries to bootstrap that by referring back to a statement made by Ms. Hicks about Plush Review. That had nothing to do with the legal notices that were published, mailed to people, and posted on the property. It had to do with Plush Review, and actually it sort of is counter-indicative of his argument because he points out that she had access to all the documents that he claims he couldn't find because of the notice problems. So it doesn't really help his claim. But it's clear that the notice worked. There were 11 people who spoke in a large crowd, and there were numerous letters submitted. And of all those people who were in attendance, there were no complaints about notice raised during the hearing. He does cite the Title IX requirements for hearing notice, but they don't support his claim either. Was the purpose stated? Yes. Were the dates stated? Yes. Was the time stated? Yes. Was the place stated? Yes. County Council Chambers. Did it describe the area to be subdivided? Yes. Did it show where the right to inspect was? Yes. Mr. Bartley seems to make some emphasis that it has to be a physical place, and it did list a physical place. The location of the hearing was provided. It is the Planning and Zoning hearing. The documents are in possession of the Planning and Zoning Department. It also provided a website, which is something that we have strived to do for the citizens of Sussex County by making documents more accessible. So the Sussex County DE.gov address was provided, where those are uploaded and available to anybody who wishes to see them. He does claim that the website is not a place, but it is a place where you go to locate the documents if you do not travel to Georgetown. And then finally, sort of as a catch-all, the address, or excuse me, the phone number of the Planning and Zoning Commission is provided to anybody that can't figure any of that out. They can call the commission and figure out, how can I see those documents? There's no issue with notice, and regardless, it was not raised below. Mr. Bartley talks about the commission's alleged failure to hold a fair and orderly public hearing. I'm not going to reiterate everything I said before with regard to the Hicks appellants, but that all applies equally here. The hearing itself, I don't think anybody disputes that it was fair and orderly, and again, you all confirmed that the first time around on remand. Mr. Bartley is focusing on my statement about the law and Mr. Whitehouse's statement about the information in the record, that it was compliant with the zoning and subdivision codes. With regard to my statement, again, that was fully compliant with your directive to consult with legal counsel. Again, that's exactly what happened. In Mr. Whitehouse's statement, he did not add any new evidence to the record. He simply confirmed what was in the record and that it complied with the zoning and subdivision codes. This was compliant with counsel's directive to consider the record all evidence and facts of the application. It is appropriate for the commission staff to advise the commission. Mr. Whitehouse is such a member of the commission and staff that he's authorized to sign plots on behalf of the commission each year. He's not just some member of the public or some third party. He's commission staff integral to the hearing and subdivision process. In fact, if staff participation was considered testimony or evidence, no record would ever be closed. And we flip it around, think about it this way. The commission could never be prevented from consulting with staff during its discussions. That's what they need to be able to do, to ask questions of staff and get information from staff. Regardless, it was merely a confirmation based on what was in the record. With regard to site plan compliance, again, I'm going to suggest that this was not raised during the hearing below, and it should not be considered again for the first time on appeal. Having said that, there were two issues that Mr. Bartley raises. One has to do with easements, and the other has to do with the grading plan. With regard to easements, he claims that there were none shown. There's a simple reason for that. None exists at the time you come in for a preliminary site plan approval. I mean, if you think about this, think about our county engineering department. They're not going to engineer a sewer plan for pipes and pump stations before something receives preliminary site plan approval. They do that after the fact. Same thing with the Delaware Electric Co-op, Delmarva Power, Tidewater, Artesian, whoever's providing water, internet, whatever. You get preliminary site plan approval, you establish where those easements go, then you should put that on the final site plan. That's just a non-issue. It was accurate, that site plan was accurate as to whatever record easement existed at the time. The second one is the grading plan. The same analysis holds true with regard to that. There were grades of the property shown on the plan, but more importantly, it was not ignored. The grading plan was a requirement for the final site plan as condition S of the Commission's motion. With that regard, the Commission does have the ability to modify or waive its requirements under Section 99-35 of the subdivision code. That happens frequently. For example, if we get a 4-lot subdivision, we're not going to require them to have a grading plan at all because that's cumbersome and really too much work for somebody that wants to subdivide off a couple or 3 lots. In this case, we required them to do it, but the Commission required them to do it at the time of final site plan, just like when they would show all those easements and everything else. So, again, the Commission was in its rights to specifically require this element to be shown at the final site plan stage. Mr. Bartley spends quite a bit of time talking about wetlands. He says wetlands means all wetlands. The problem is Mr. Bartley doesn't tell us what he means by what a wetland is. There are 2 types of wetlands. There's regulated versus unregulated. Unregulated just being areas that happen to be wet. We define wetlands in the code as federal or state. Federal regulated by the Corps of Engineers, state regulated by DENREC. Mr. Bartley expects the county to regulate other soil types or damp ground areas, but never provides any authority for that, again, because there is none. Regardless, he cites to Section 115-25E that all lots must be configured to be outside of all wetlands. 115-25E doesn't apply to this subdivision. This was, recall, a coastal area subdivision. 115-25E is within the requirements for an AR1 cluster subdivision. There are 2 different standards. The wetlands section that he cited does not apply to this type of subdivision. And that was actually confirmed in finding number 4 of the Commission's decision, which neither appellant challenges. So again, Mr. Bartley's reliance on 115-25E is misplaced. In the site plan, there are 5.65 acres of non-tidal wetlands that are regulated by the Corps. By the Commission's decision, those won't be disturbed. They are buffered, and they actually got conditions imposed to protect them. There was denial of that bonus density so that lots would be pulled away from them. As I mentioned, there was a road that was relocated to be pulled away from those wetlands. Mr. Bartley claims that there were 18.36 other acres of land that happens to be wet at times that should not be touched. Again, there's no regulation to support this. And as I was thinking about this, having lived through the buffer ordinance and some other things that we talked about having to do with wetlands, I can't imagine the Commission or you all telling farmers that lands that are unregulated and may be damp are suddenly unbuildable. They have to be based on the code requirements. Again, the regulated wetlands were protected adequately through the conditions of the approval. And finally, the density calculation that was raised by Mr. Bartley. I'll admit it took me about 5 times to read that to understand what he was stating in that. And I think basically I came to the conclusion that what he is asking the Commission to do, and you all to affirm, is that you determine density based on a site plan, not based on the zoning code. Density is based on what the zoning code says. He also plays around with the reference to what a lot is. At the time of subdivision, the lot is the entire parcel. If you've got 100 acres, it's a 100-acre lot. That's what you determine density off of. So if you have 100 acres, you get 2 units an acre, you got 200 lots. That's how you do it. What he would do, or say you have to do, is you take that 100 acres, you design a subdivision on it. You figure out where the lots are, where the roads are, where the common open space is, knowing that you would never actually build that subdivision. You would design that subdivision so that you can figure out what your density is. I'll say, okay, I've got 100 acres. I can put 200 lots on there. I know that there's 200 lots and the open space covers 160 acres. Then, under his logic, you got to take that 160 acres, multiply that times 2, and figure out, 160 lots. Let me back up. I messed that up. If you have a 100-acre subdivision, you get 200 lots on that subdivision. You design it with those 200 lots, with the road and with the open space. Then you determine the acreage covered by those 200 lots and that common open space. That gives you 60 or 80 acres covered by those things. And then that determines your density. So once you have that first subdivision design, you figure out what's covered by lots and open space. That gives you your density. And then you have to design a whole new subdivision based on that acreage and density calculation. That's not how it works. That would be a waste of everybody's time and resources. And plus, it would be never-ending, because then you'd have another site plan with lots on it and open space that would give you acreage that you'd have to then calculate density and then design another subdivision based on it. It's never-ending. And there's a simple answer to that. It's not based on site plan design. It's based on what the code says, and that's the 2 units an acre that's out there in our zoning code. So I think that's covered most all of it. I think in closing, I just want to summarize. Nobody's disputed that planning and zoning misapplied or misinterpreted the county code. Nobody even disputes the law that I read to the Planning and Zoning Commission and my explanation to them. They don't like that I told them what the law is, but they don't say what I said was wrong. So let's start with that. And the fact of the matter is, you all directed me to give that advice, and it was the second time that I had done it. The Planning and Zoning Commission's findings were the result of an orderly and logical review. Let's think about what that includes. That was the initial hearing back in January that lasted forever, where we heard a lot of information from the applicant, people with an interest, people opposed to this application. Then we had another vote based on a motion that was substantially similar to the one that they considered earlier this summer. All of that was the result of an orderly and logical review. And we can look at the product that was that motion, where there were 16 findings and 21 conditions of approval. It wasn't as though somebody just said, yes, I like this subdivision, I vote in favor of it. There were 16 findings and 21 conditions of approval. It was not a rubber stamp, and nobody should be suggesting that it was. And then finally, council's instructions on remand were followed. For all those reasons, I would submit that the commission's decision should be affirmed this morning. Thank you.
Good morning, Your Honor, and members of council. My name is John Horner. I'm the general counsel for Shell Brothers, LLC, the applicant for the Coral Lakes project. The procedural posture of this appeal has already been outlined by others, so I won't spend additional time repeating it. I'd like to start out by saying Coral Lakes is a by rights application, meaning the property is zoned AR1, and the proposed use of the project is residential single-family housing consistent with the AR1 zoning. The appellants today consist of some immediate neighbors of the project, as well as an individual who lives miles away from the project. Today we are here because those appellants are asking you to disregard the law, the Constitution, property rights, and the sound, orderly, and logical review of the Planning Commission because they do not want this project near them. Why don't they want it? Well, for the Hicks appellants, that's a simple question with a simple answer. They live next door to the project, and they've enjoyed wooded views from their homes as well as the unrestricted use of that forest. Upon hearing of this application, they immediately began opposing it under the premise of preserving the forest, despite the fact that the same forest they are allegedly trying to protect is the exact same forest which was cut down for them to build their homes and the road servicing their homes. I understand where the Hicks appellants are coming from. I think if given the option, we would all prefer to have a forest in our backyard that we didn't have to pay for rather than homes. Or, given the option, we'd want to be able to tell our neighbors exactly what to do with their land or to tell our neighbors that we want their land to remain untouched. Luckily for the applicant, the rule of law still prevails in this country, and a neighboring property owner's desire to control the use of someone else's land is trumped by the property rights of the owner of that land. The same property rights that allowed each of the appellants to build their homes are the same property rights that demand the affirmation of the approval of this application. With that being said, Ms. Maury will be addressing the appeal filed by the Hicks appellants, which I can honestly say is the first time I've heard a lawyer argue that you should not follow the advice of your lawyer. And I will be addressing the appeal filed by Mr. Terrence Bartley. I'd like to first start with a brief recitation of the standard review, even though you've heard it a little bit before. Some of what you're going to hear, Mr. Robertson stole my thunder, but I'll try to keep it concise. The Planning and Zoning Commission, I apologize. The council may only reverse the decision of the Planning and Zoning Commission upon a finding that the commission made an error in its interpretation of the applicable sections of the subdivision code, or that the commission's findings and conclusions were not the result of an orderly and logical review of the evidence and the applicable provisions of the subdivision code. If there is substantial evidence that demonstrates the commission's decision was based on an orderly and logical review of the evidence, and the law was accurately applied, the council must uphold the commission's decision. The burden of proof is on the appellant, here the Hicks and Mr. Bartley, to show the commission erred and there was no orderly and logical review of the evidence. As this council stated in the Terrapin Island appeal, the council's review is limited to correcting errors of law and determining whether substantial evidence exists to support the commission's findings of fact, and that when substantial evidence exists, the council will not reweigh it or substitute its own judgment for that of the commission. Simply stated, this council is not reviewing this matter de novo or anew. The review is limited to reviewing the process and the findings of the commission. Prior to addressing Mr. Bartley's substantive arguments, I'd like to first address the threshold issue of standing. Mr. Bartley lacks standing to pursue this appeal under Delaware law and legal precedent, as well as under the Sussex County Code. Because he lacks standing, his appeal must be dismissed. Delaware courts have stated clearly that for an individual to have standing in a matter like this, they must demonstrate the interests they seek to protect or within the zone of interest the ordinance seeks to protect, and allege a related injury in fact. With regards to the injury in fact, the courts have further said that the appellant has to have suffered an injury that is concrete and particularized. The injury is fairly traceable to the challenge action, and the injury can be remedied by a favorable decision. Similarly, Sussex County Code confers standing only to an appellant that has been aggrieved by the decision of the commission. It does not use broader language such as a citizen of Sussex County, a taxpayer of Sussex County. It specifically says an appellant must be aggrieved by the decision of the commission. Let's analyze those two standards briefly. Looking first at the Delaware case law standard, Mr. Bartley does not allege or even attempt to allege any particular harm that is concrete and particularized. This is because he does not live by the Coral Lakes Project. He lives miles away based on his address and his appeal filings, and there is no particularized harm that would befall him with the approval of this project. As such, he's not met this burden of showing an injury in effect, and the appeal must be dismissed under Delaware law. Looking next at Sussex County Code, Mr. Bartley cannot say he has been aggrieved by the decision of the commission. A review of the record shows Mr. Bartley did not participate in the public hearing stage at all. He did not testify, he did not write letters, he did not sign petitions, he did nothing. How can someone who declined to participate in the process claim to be aggrieved by it? If this council allows appeals of this nature to proceed, it opens the door for nonstop nuisance appeals of by right subdivisions. What's next? A person from Delmar appealing a subdivision near Milford? The Citizens versus Smyrna Clayton first case cited in our filings is dispositive here. In that case, the court answered the question of whether an adjoining landowner, which Mr. Bartley is not, had standing to challenge an approval as being contrary to law. The court held no in that matter because the plaintiff could not establish an interest that was distinguishable from other residents of the town, and here, in this case, the county. And because Mr. Bartley cannot establish any injury that is different from other residents of the county, he lacks standing. When confronted with the issue of standing in his reply briefs, Mr. Bartley cited to 9 Del C 6811 to state that it confers standing upon him. However, 9 Del C 6811 just broadly states any approval or disapproval may be appealed to the county government within 30 days of the official action of the county government. Mr. Bartley seemed to add in Sussex County residents are granted standing by this. That is not the case. There are several statutes throughout the law that grant appeal rights. Specifically, the Court of Common Pleas, you can appeal to the Superior Court. That does not mean that any party can appeal to the Superior Court. It only means parties with standing can appeal. If this language had specifically included, as was the case in a recent decision by Judge Carstens, language that said a taxpayer or a resident had an appeal right, then standing would be conferred as a matter of statutory interpretation. Here, it does not. Mr. Bartley's interpretation would confer standing on anybody, anywhere, solely because an appeal right exists, and that simply is not the law. He next argues standing based on vague constitutional protections and due process related to those notice requirements. In fact, courts have consistently held the opposite. There's numerous cases cited throughout our briefs that essentially and specifically say that you do not have a constitutionally protected right in the by rights land use of another landowner. It is that landowner that has the constitutionally protected right, not you. Said more clearly, a member of the public does not have a protectable constitutional right in property owners' right to use the property. The cases cited by Mr. Bartley dealing with this dealt specifically with rezonings or conditional uses, not by right subdivisions. Again, based on Delaware law and a clear reading of Sussex County Code, Mr. Bartley's appeal must be dismissed due to lack of standing. Mr. Bartley alleges the public notice for the public hearing was deficient because it did not state the place in which the text and maps related to the proposed change may be examined. Mr. Robertson covered this in great detail, but in short, the place and where the maps could be located and studied was provided. A website was provided, an address was provided, a phone number was provided, and all of these meet and comply with the code. Mr. Bartley seems to argue that a website is not a place, and therefore it needs to be a physical place for inspection of these documents, and that these documents cannot exist in multiple places. That seems illogical to me. We can copy things, we can scan things, we can reproduce things, and generally you would want these documents to be available in as many places as possible to allow for the most public involvement. And notably, as Mr. Robertson pointed out, there is no allegation that the appellants were unable to find these documents. In fact, quite to the contrary, these documents were specifically referenced in public comment during the public hearing process. Although it's interesting that, and you'll hear this a lot throughout discussing this, but this notice issue was never raised by Mr. Bartley or anyone during the public hearing process. And again, this same county council in the Terrapin Island appeal stated clearly that an issue that was not raised before the Planning and Zoning Commission cannot be subsequently raised on appeal when it stated, and I quote, "Council is not permitted to consider any issues and arguments raised by appellant on appeal that were not raised below as they are considered waived on appeal. To allow an appellant to do so would create due process violations and incentivize plan opponents to sit back and raise the issue only on appeal, prejudicing the applicant and wasting governmental time and resources to handle frivolous appeals." In his reply briefs, Mr. Bartley cites a case from a Florida state court interpreting Florida law for the premise that new issues can be raised for the first time on appeal under the fundamental error doctrine. This doctrine in Delaware has only been loosely applied in the context of criminal law cases for what we could find, and each of those required a deprivation of a constitutional right in order for there to be fundamental fairness implicated. Here, as stated before, there is no constitutional right implicated for an adjacent landowner or another member of the public related to a by rights use of land by a landowner. And again, Mr. Bartley did not participate in the public hearing process at all. Despite ample opportunity to raise this issue, he did not. However, even if he had, the notice was complied with and the provisions of the law were complied with. Mr. Bartley next argues that an orderly public hearing was not held, and he bases that assertion on a comment made by staff outside of the public hearing during the deliberations on the application triggered by this council's remand. Mr. Bartley argues that the colloquial use of the phrase "for the record" when Mr. Robertson asked Director Whitehouse to confirm the application complies with the subdivision and zoning code somehow turned the deliberations into a new public hearing. That's not how this works. The Commission is allowed to consult with its staff, including its attorney and planning and zoning staff, and these deliberations and discussions are customary and ordinary, and in fact encouraged. Furthermore, Mr. Whitehouse's statement was not new. It was a confirmation of facts already in the record and confirmed by the motion of the commissioners previously made. Mr. Bartley's approach would render it impossible for planning and zoning staff and its attorney to do their job, and for the commission to consult their expertise during deliberations. It would create a veritable minefield wherein any remark by a staff member or the commission's attorney would trigger new notice and hearing requirements. This is not how the process works, and Mr. Whitehouse's confirmation that the application meets the code did not create a new public hearing and thus render the public hearing not orderly. And to that point, as Mr. Robertson indicated, this council has already found in the prior appeal that the process was orderly. Specifically, and I quote, this council found that the commission engaged in an orderly process such that the applicant filed the application, the commission received and reviewed the comments and reports from various state agencies, the public, etc. A public hearing was held and the commission discussed the issues before it. As such, there's no possible logical rationale for overturning that decision, as the law of case doctrine, as we've outlined in our briefs, applies. But speaking plainly, I don't know how you turn an already orderly review into an unorderly one. Now, even if you agree with Mr. Bartley that Mr. Whitehouse's statement somehow constituted testimony in a new public hearing, the remedy would be to disregard his statement. And even if that were done, substantial evidence still exists to uphold the decision of the commission. Mr. Bartley most likely did not like the confirmation by Director Whitehouse because he bases some of his argument on appeal arguing that the plan does not comply. Specifically, Mr. Bartley wrongfully states that Section 99(8)B requires the planning and zoning staff to confirm the plan's compliance with the code. That does not comport with the plain reading of that statute. Specifically, that statute requires the plan to be checked by the staff to determine its conformity with the law. That review occurred, and it's undisputed that it occurred. The staff provided a response letter, and then the applicant responded to those comments. The planning and zoning staff, specifically Director Whitehouse, then confirmed that the plan met code. Mr. Bartley seeks to avoid this fact in his latest filing by raising new issues for the first time, which again is not permitted. The bottom line here is that the plan complies with the code as confirmed by Director Whitehouse and the extensive record. The review by staff required under 99.8B occurred, and the staff again confirmed that it complies. Mr. Bartley cannot overcome these facts. Mr. Bartley next wrongly asserts that the application does not comply with the code because the application has lots configured within the wetlands areas. As Mr. Robertson indicated, this is a coastal area subdivision and not a cluster subdivision. The provision cited by Mr. Bartley related to lots being located in wetland areas is not applicable to this project. But again, even if it were, Mr. Bartley is simply wrong here. First, it is important to note that despite Mr. Bartley's contentions, wetlands under state, county, and federal law does not, in fact, mean all wetlands. There are regulated wetlands on the property, but those are located at the rear of the property and will not be disturbed. In fact, those jurisdictional wetlands have buffers around them in excess of what is required by code, and in fact is in compliance with or in excess of the wetlands buffer ordinance that was passed subsequent to this project and not applicable to this project. The areas where the lots are located do not contain any wetlands that are regulated by federal, state, or county law. Those areas, which are better described as low wet areas than wetlands, fall outside the scope of regulation for the county, which refers to the federal and state definitions promulgated by the federal government and DNREC. Testimony reports provided by the applicant and its expert in the record, including a jurisdictional determination from the Army Corps of Engineers, indicated clearly that these low wet areas where lots will be constructed are not wetlands subject to any governmental jurisdiction and do not meet the definitions of wetlands promulgated by DNREC or the federal government. This same interpretation of what constitutes wetlands subject to the jurisdiction of the county has been utilized by the Commission in multiple project approvals, including the recent approval of the Eastgate subdivision, which contained lots in isolated wetlands not subject to any governmental jurisdiction. As noted in our submissions, the Commission's interpretation of the code should be given deference, and furthermore, the applicant relied on that interpretation when submitting the application. Accordingly, as set forth in our submissions, the doctrine of equitable estoppel prevents this council from arbitrarily changing that interpretation in the middle of the application process. Furthermore, to the extent any ambiguity exists in the law, and we feel the law is clear here on the definition of wetlands and what is and is not regulated, any ambiguity would be construed in the favor of the landowner, as the landowner is the party with the protectable property interest. In short, Mr. Bartley is again plainly wrong with his argument here. He wrongly asserts this code provision applies to the project when it does not, and he wrongly states that the wetlands where lots are located are jurisdictional wetlands subject to the regulation of the county. One last point I would like to make is that recently the county did pass the wetlands buffer ordinance, and in that process they reviewed resources that were in need of protection. That ordinance specifically again reaffirmed the intent not to regulate these low isolated wetlands, as it does not contain any buffers or regulation of these low isolated wet areas. The last of Mr. Bartley's arguments relates to the density calculation for the proposed subdivision. As stated previously, this issue was never raised below, and based on relevant case law in this council's Terrapin Island decision, the council may not consider this issue on appeal. However, even if the council were to consider this issue on appeal, Mr. Bartley is again wrong. First, it is important to note that density is a function of zoning and is calculated for a property based on the zoning for the property. As such, the density for the Coral Lakes property is established and calculated prior to the submission of plan and does not change with the submission of a plan. At the time density is calculated for Coral Lakes project, the project was 2 tax parcels or 2 lots. The definition of gross area, as defined in the code, resides in the zoning code and not the subdivision code, and specifically includes the lot areas and the area of land set aside for common open space or recreational use, but shall exclude any area designated as a tidal, tributary stream, or tidal wetlands. Again, density is determined in the zoning code, not the subdivision code. Here, at the time density is calculated, the entirety of the Coral Lakes project consisted of a gross area, as defined by the code, of 152.34 acres, which allows for 304 lots, exactly what was approved here. Mr. Bartley attempts to shoehorn in a definition of open space into the definition of common open space, which is not defined in the code. However, that definition of open space or common open space is irrelevant when one reads the definition of gross area. Gross area includes lot areas and the area of land set aside for common open space or recreational use. At the time of the application and the determination of density, the entire project was within lots. You do not even need to get to the next step of analyzing common space or open space because you've already satisfied lot areas. The Commission and this Council have a long-standing historic practice of calculating density in the exact same manner as it was calculated for Coral Lakes. As outlined in the submissions, deviating from that interpretation would create due process violations, throw every prior AR1 approval into question, of which, as you all are aware, there are many, and create equitable estoppel issues. Lastly, I'd like to direct everyone's attention to Mr. Robertson's brief on this point, and he also articulated it. But if you were to apply Mr. Bartley's interpretation to the code, it would create essentially an endless loop of redesigns wherein you design a project, then you have to measure the area of the roads and other impermeable surface. That's going to then reduce the amount of lots you have. You then would have to reduce your lots, redesign the project, recalculate the area of impermeable surface, and do it again and again and again until you essentially end up with one lot, which is clearly not the intent of a subdivision code. In closing, it's clear that the Planning and Zoning Commission conducted an orderly and logical review of the record and properly applied the law when approving Coral Lakes. As such, this council should affirm the decision of the Planning and Zoning Commission. I now defer to Ms. Mowry, who will be addressing the appeal filed by the Hicks appellants.
This is not a lot that hasn't been said yet, but I will try to just briefly cover a few points on the Hicks appeal. I'm Kate Mowry of Richards, Layton & Finger, representing Schell Brothers. Good morning, Judge Tolliver, council members. Thank you for your time this morning. I think it's truly remarkable, the argument being made here today by the Hicks appellants, that somehow the commission did something wrong by following the advice of their legal counsel. Yes, I think that is the crux of their argument, that it was illogical and disorderly and an improper application of law to have legal counsel advise on Delaware law and then to follow Delaware law. And as you've heard, it's not what advice was provided. It's not the Delaware law was incorrect in the way that it was provided. It was correct, and it was the Delaware law. And the Hicks don't object to the way that it was presented or the actual substance therein. It is just the fact the commission shouldn't have followed basically the advice on Delaware law. Or that somehow legal counsel, that he made the decision for the commission by reading that Delaware law into the record and reading Commissioner Mears' motion into the record. That's not correct. What legal counsel did here is compliant with law and absolutely appropriate, and in fact the job of legal counsel. What he did is, again, this counsel told him to consult with the commission, and that's what he did. Not sure what else legal counsel would do if not advise on Delaware law. This appeal on that attenuated argument can be dismissed quite easily. In addition to the reason that it is an attenuated argument, the procedure taken during the June 23rd commission hearing, including legal counsel's advice on Delaware law and the commissioners following that law, complied with this counsel's instructions on remand. It complied with this Delaware and Sussex County Code, the commission's procedures, Delaware law, and prior precedent of this counsel. And on that last issue, you did not hear the Hicks appellants here today talk much about prior precedent. I will mention, as you all probably recall last year, the same council affirmed Terrapin Island's preliminary plat approval. And that decision was based on a procedure almost identical to this one here. The only difference is that here in Coral Lake's application, actually additional evidence of careful consideration was provided than in Terrapin Island. So Schell submits that it cannot be that this council would find that process logical and orderly and the proper application of law, and not this one. I do want to talk about the record, but before I do that, I'll note that for the same reasons as outlined by Mr. Horner and in the arguments in our briefing, the Hicks appellants do not have standing to bring their claim. It is their burden. They've not met it with their generalized concerns. Getting to the record, the appellants argue that Schell is fleeing from the record. I think you heard them running from the record even today. It's actually the opposite. Schell accepts the record as it stands, which shows an orderly and logical review and proper application of the law, and we set that forth in our papers. We were not hiding from anything. The Hicks, however, seem to be the ones fleeing from the record, right? They want to ignore a large portion of it, in fact. They want to ignore the 12-page, I counted 12 pages of transcript motion made by Commissioner Mears. And it is improper on this appeal to ignore any part of the record below. It is counsel's, they need to review the entire record, which would include the motion itself. The Hicks would have the motion completely written out of the record, which is just not the case. I don't know if I know how to do this, actually.
Bring the mouse down and it'll pop up.
Oh, down here. And you all have this on your desk, but I just did want to point to the motion itself, as it hasn't really been raised much by the Hicks appellants. Here's the motion. I pulled it from the June 23rd meeting minutes, and in a quick glance, it's clear to see that this in itself would have been sufficient to show an orderly and logical review of the evidence. It's extensive and detailed. It spanned, as the Hicks appellants have said, 11 pages. I counted 12. The motion, I can't even fit it on one screen here. The motion contains a recitation of Delaware law, 16 findings, 21 conditions, specific reference to the code requirements and that the application met those requirements, a statement that the motion is based on the hearing record below, reference to specific testimony and evidence of that hearing, and conditions that specifically address unique aspects of the evidence that were presented at the hearing. That was all presented in our hearing, that was all in our briefing as well. In Terrapin, I want to note, the council found a motion just like this one, very similar in format, showed careful consideration of the record. And there's no reason that the same is not true here. Additionally, if that wasn't enough, the commission did more than just this motion and a voice vote, which is what happened in Terrapin. They read the motion, they did a voice vote, and that was sufficient. Here, there was also the fact that each commissioner stated reasons for his or her vote. And that's actually more than what was done in Terrapin. And that's what this council asked the commission to do on remand. And I'll briefly go through each one of those votes, just so that you can see that they show logically an orderly review and proper application of the law, and are not, in fact, post hoc rationalizations by council. You can read the actual reasons yourself as I click through them. Commissioner Wingate, I am a yes for the extensive explanation by council on the conditions imposed. I'll remind you the extensive explanation by council was an explanation of Delaware law, and then the reading of Commissioner Mears' motion. So I'm not sure what else the Hicks appellants would require here that Commissioner Wingate say. Commissioner Wingate is agreeing with Delaware law and the motion, as well as the conditions. Commissioner Mears, Mr. Chairman, I voted against this application because of the trees, the wetlands, the flooding, etc. Unfortunately, as council explained, it complies with the subdivision and zoning code. Therefore, I vote yes based on the reasons in the motion. Again, legal counsel explained Delaware law and read Commissioner Mears' motion into the record. Commissioner Mears is agreeing here that the application complies with the subdivision and zoning codes, as stated by, by the law. The law was stated by legal counsel. He adopts the motion and then votes in favor of it. I'm not sure what's wrong here or what more could possibly be required. Commissioner Wheatley says, and the chair votes yes for the reasons stated in the motion and for the simple fact that we simply have to honor the rule of law as it's written. I don't think it gets more clear than that. Each of these votes shows individual consideration and independent articulation, an agreement with the motion and the conditions. Further, there is no evidence, and you can look at the record upside down, sideways, and there's nothing in that record that legal counsel directed the commissioners on how to vote. He stated the law of Delaware, and he read Commissioner Mears' motion into the record. There were also 2 commissioners who did not vote in favor of the application approval, which shows that there was individual thought by each and articulation and consideration by each commissioner, and that legal counsel did not direct the vote. And I'm putting up Commissioner Stevenson's here. She says, I'm not voting because I was told what our counsel said was that we can't deny it. And the reasons I am is that I'm not opposed to this property being developed, even at the proposed density, but I do have serious concerns with the site plan. Again, as I said, this shows individual thought and articulation. To the extent the appellants argue our counsel said that we can't deny it, shows legal counsel told them how to vote, that's incorrect. Because first of all, you have the full record of the June 23rd hearing. Read it. There is nothing in that where Mr. Robertson tells the commission how to vote. What this means, what Ms. Stevenson is saying here, she's tacitly understanding that because Coral Lakes meets all of the subdivision and zoning codes, it can't be denied under Delaware law, as articulated by legal counsel. And as a result, because she refuses to vote in favor, despite Delaware law, she abstains. And then finally, there's Commissioner Hopkins, who voted no because of issues with wetlands. Again, this shows individual consideration and no direction by council. As I said a couple times, the appellants complain about the procedure, but it's unclear under their position what would have been sufficient. And nonetheless, what the commission did here complies with Delaware statute, as well as Delaware case law. Under 9 Delaware Code 6811, that only requires grounds for decision when a plat is disapproved, not when it's approved. And that makes sense. If the plat complies with the code, it complies. There's no reason to then restate each way in which it complies, right? A vote in favor of the motion is a vote stating that the plat application complies with the code. If it doesn't comply, then it makes more sense to have to explain why it doesn't, and because it could be taking away property rights from a landowner. With respect to Delaware case law, the cases cited by the appellants actually clearly provide that the procedure here provides this council with sufficient clarity. Former Vice Chancellor Slice and T.D. Rehoboth states there, he's referring to council because that was on a rezoning application, but he says council does not have to follow any particular roadmap when reciting the grounds for its decision. Perfection is neither expected nor required. Instead, it is enough that council states its reasons with sufficient clarity that the court is not left to guess why the decision was made. As I just went through each one, there is no room for guessing. Each one explained that they approved, the three that approved the plan explained why they did so. Finally, in addition, the commission followed remand instructions. I think that's been covered. It was in our papers. And by Mr. Robertson. They've complied also with this council's precedent. And here's where I will just touch again on Terrapin Island, and I'll put up, the procedure that was taken in Coral Lakes, as well as the procedure that was done in Terrapin. I'll walk you briefly through it, as I assume you all have had things come up in the time since it's happened, and I'd like to show you how it is procedurally almost identical. And where it's not, the commission did more in Coral Lakes, favoring affirmation here. So in both, Commissioner Mears made a motion. In both, legal counsel was asked to read the motion into the record. In both, the motion had findings and conditions based on the record below, extensive and detailed. In both, the motion was seconded. In both, there was an opportunity for discussion, which the Hicks don't even mention that in Coral Lakes there was an opportunity for discussion prior to the motion being read. In both, there was a vote. In Coral Lakes, there was actually additional reasons given than in Terrapin, and in both, a written decision was provided to the applicants. Based on this record, it cannot be that where the same procedure is undertaken in one appeal and affirmed, that it isn't in the second. That would undermine confidence in the council and appeal.
Exhausted your time.
Oh, yes, sorry, I didn't even see that. But for all these reasons, I was actually at the, I do want to note that we don't ask for, we're opposing a remand here because 9939B2B, council can only remand if there wasn't a logical and orderly review. There was one here. It should be affirmed because the plat complies with applicable code, and any more further delay is prejudicing shall. Thank you for the additional 58 seconds. Thank you.
Rebuttal? No. Okay.
Thank you. I will try to, I believe I reserved 5 minutes. I'll try to keep it at. On standing, the Planning and Zoning Commission wasn't challenging Hicks's appellant's standing, and I thought Mr. Horner wasn't really going down that standing route, and then Ms. Mowry mentioned it. So let me be very clear. We cited in the record to the January 27. There are numerous references where these people who did testify articulated specific impact to them, including at pages, Mr. Baboshka at page 65, Ms. Hicks at page 68 and 70, Mr. Hicks at page 92, Ms.